2026 ruling in Jack Henry versus Plano Encryption Technologies means a startup's own cease and desist letter can turn its patent holder into a defendant in the wrong court. The conventional advice to a startup with a valuable patent portfolio has always been simple: enforce it or lose ground. That advice now comes with a trap most founders do not see coming. Because the same artificial intelligence tools that let a small company monitor the entire market for infringement and generate a claim chart in hours rather than months also make it dramatically easier to send a cease and desist letter into exactly the wrong jurisdiction. Start with what has actually gotten easier. Artificial intelligence-powered patent monitoring platforms now scan news coverage, product manuals, e-commerce listings, technical publications, and conference papers to identify candidate infringing products at a scale and speed no human analyst team could match. These platforms generate claim charts, structure comparisons showing element-by-element overlap between a patent-specific claims and an accused product's actual features, and they continuously reassess their infringement conclusions as new information about a product becomes available, effectively running a permanent, low-cost surveillance operation across a company's entire competitive landscape. For a startup with a meaningful patent portfolio and no in-house patent litigation team, this is a genuine capability upgrade. Work that once required a six-figure engagement with outside counsel to even begin identifying candidate targets can now be triaged internally at a fraction of the cost, with outside counsel engaged only once a credible target has already been identified and the claim chart has already been drafted. That capability arrives at a moment when the underlying litigation environment has become considerably more aggressive. Non-practicing entities, companies that hold patents but manufacture nothing and offer no products or services, added 2,236 new defendants to their patent litigation campaigns in 2025, an increase of 18.7% over 2024, itself up 22% over 2023. The technology sector absorbed the largest share of this activity, accounting for 44.8% of all non-practicing entity litigation volume by industry in 2025. A meaningful driver of this growth is procedural rather than substantive. Discretionary denials at the Patent Trial and Appeal Board have increased since March 2025, which has reduced the odds that a district court will stay litigation pending a post-grant validity challenge, making it more attractive for patent assertion entities to file suit directly in district court rather than first seeking review at the board, where they previously faced a higher chance their case would simply be paused. Legitimate operating companies with real patent portfolios, not just non-practicing entities, are adopting the same automated monitoring approach for defensive and defensive purposes simultaneously. A startup that built a truly novel piece of technology and secured patent protection around it has every right to monitor the market for infringement and to enforce those rights against competitors who copy the innovation without licensing it. The problem is not the monitoring. The problem is what happened procedurally once the monitoring platform identifies a target and the company moves, often quickly and sometimes through an automated or templated workflow, to send a cease and desist letter. The Federal Circuit's decision in Jack Henry and Associates Incorporated v. Plano Encryption Technologies, LLC established a rule that automated patent enforcement programs must build into their process from the outset. The court held that merely sending a cease and desist letter into a forum can itself establish sufficient minimum contacts with that forum to support personal jurisdiction over the sender, meaning the recipient of the letter can file a declaratory judgment action against the patent holder in the recipient's own chosen court, often a venue considerably less favorable to the patent holder than the one the patent holder would have selected for itself. The court's reasoning reflects a considered judgment that when a patent holder reaches into a jurisdiction to threaten litigation, it should expect to be sued there if the recipient disputes the claim, rather than enjoying the unilateral choice of when and where any resulting dispute gets litigated. This creates a genuine tension for any startup using an automated or semi-automated patent enforcement workflow. The entire value proposition of artificial intelligence-assisted monitoring and claim chart generation is speed and volume. Identify more potential infringers faster at lower marginal cost per investigation. But speed and volume are precisely the conditions under which a legal team is least likely to conduct the individualized forum analysis that sending a cease and desist letter now requires. A templated letter sent to 50 candidate infringers identified by an automated monitoring platform, without individualized review of where each recipient is located and what forum each letter effectively selects, multiplies the company's jurisdictional exposure by exactly the same factor that made the monitoring platform valuable in the first place. Here is the unexpected implication for patent portfolio strategy generally. The rational response to this tension is not to abandon automated monitoring, which remains a genuine and valuable capability upgrade for resource-constrained startups. The rational response is to decouple detection from enforcement action, treating the automated platform's output as an internal triage list rather than a trigger for immediate outbound correspondence. A startup should build a deliberate human review step between the moment its monitoring platform flags a candidate infringer and the moment any letter goes out, with that review specifically addressing where the recipient is located, what forum a cease and desist letter would effectively invite, and whether the company would actually want to litigate the underlying infringement claim in that jurisdiction if the recipient chooses to file first. This is a small process addition relative to the overall automation the platform provides, but skipping it converts a defensive cost-saving tool into an offensive liability generator. The policy environment adds a further layer of urgency to getting this right. The Restore Patent Rights Act of 2025, currently pending in Congress, would restore a rebuttable presumption of injunctive relief for patent holders who prevail on an infringement claim, a change that would significantly increase the settlement pressure available to any patent holder, legitimate operating company, or non-practicing entity alike, because the credible threat of an injunction forces a defendant to weigh an existential business risk rather than simply a monetary damages exposure. If that legislation passes, the value of a startup's own patent portfolio as an enforcement asset rises considerably, which will only increase the incentive to move quickly and broadly using automated tools. Exactly the conditions under which the personal jurisdiction risk identified in Jack Henry is most likely to be triggered inadvertently. The economics of patent monitoring as a subscription service reinforce why this is becoming standard practice, rather than a niche capability reserved for large companies with dedicated intellectual property litigation groups. Platforms in this category are generally priced on a subscription or per portfolio basis, rather than the hourly billing model that has traditionally made comprehensive infringement monitoring prohibitively expensive for a company with a handful of patents and no litigation budget. A startup that owns even a small number of truly valuable patents can now justify continuous monitoring in a way that made no economic sense 5 years ago, when the only alternative was periodic, manually conducted infringement sweeps commissioned at significant expense and therefore performed rarely, if at all, leaving most of a company's patent portfolio effectively unmonitored between engagements. The claim chart itself deserves particular attention, because it is the document that will eventually matter most if a dispute proceeds toward litigation or licensing negotiation. An artificial intelligence-generated claim chart, mapping specific claim elements to specific features of an accused product, provides a strong starting point for evaluating infringement, but the underlying claim construction, the legal determination of what a given claim term actually means and how broadly it should be read, remains a task for a patent attorney rather than an algorithm. Two claim charts that look superficially similar can rest on very different claim construction assumptions, and a company that treats an automated claim chart as litigation-ready without attorney review of the underlying construction is building its enforcement strategy on an assumption that has not actually been tested. Startups on the receiving end of an automated or template-driven cease and desist letter face a mirror image version of the same dynamic, and understanding the sender's likely process is itself a useful defensive tool. A demand letter generated from an automated claim chart, sent as part of a high-volume campaign against many candidate targets simultaneously, often shows recognizable signs. Generic claim language mapped loosely onto the recipient's product without close attention to the recipient's actual implementation. Aggressive settlement demands calibrated to encourage a quick payment rather than a contested fight, and response deadlines set unrealistically short. A startup receiving this kind of letter should resist the instinct to respond immediately and instead have counsel assess, first, whether the underlying patent is even valid and enforceable, and second, whether the sender's own jurisdictional exposure under the Jack Henry rule creates an opportunity to file a declaratory judgment action in a more favorable forum before the sender does anything further. The broader lesson for any startup building a patent enforcement or defense capability in 2026 is that automation changes the volume and speed of legal action without changing the underlying substantive law governing that action. Claim construction still requires legal judgment. Personal jurisdiction still turns on where a letter lands and what context that letter creates. Injunctive relief. If the pending Restore Patent Rights Act eventually restores a presumption favoring it, will still require the patent holder to actually prevail on the merits of infringement and validity. Every advantage artificial intelligence tooling provides is an advantage in speed and cost, not a substitute for the legal analysis that determines whether a given enforcement action or a given defense against one actually succeeds. Startups building or acquiring meaningful patent portfolios in 2026 should treat automated patent enforcement the way sophisticated litigators have long treated any high-volume legal process, valuable for what it speeds up, dangerous the moment speed substitutes for judgment. The platforms that generate claim charts in hours rather than months are a genuine advance. The decision to send a letter based on that claim chart still belongs to a lawyer who has asked, specifically, whether the company wants to be sued in the forum that letter is about to select. Interested in analysis about the intersection of corporate law, securities regulation, tech, artificial intelligence, public policy, and the law? Check out my Substack channel, https://theinnovationattorney.substack.com.